Welcome to Criminal Law Unfiltered.
Hello, and welcome back to Criminal Law Unfiltered with Robert M. Helfend. Robert is the founder of Helfend Law Group and has spent more than 40 years defending clients in serious state and federal cases across California and nationwide. With thousands of cases behind him, he's known for strategic, aggressive defense when the stakes are the highest. I'm Heidi Mack, and today Robert is going to walk us through the timeline of criminal cases. This episode is How Long Does a Criminal Case Take? Thank you again for joining us, Robert. We really appreciate it.
Thanks for having me.
Wonderful, wonderful. Well, let's get to it here. Robert, when someone is facing a criminal case, what's the first thing they need to understand about how long it might take?
There's a lot of factors that go into that. One of the major factors is where the case is. So in LA County, for instance, we have 5 counties that are next to each other. Ventura, you have Santa Barbara, Orange County, LA, Riverside, San Bernardino. And each jurisdiction has their own little rules. And also, when a judge starts perking up and going, hey, you need to move this case along. Another factor is what kind of case it is. So if you have a murder case, it's going to take 2 or 3 years before you either get it to trial or you're able to maybe get a reduced charge and settle the case. So it takes a long time. I would say, a murder case, a couple years, maybe your average felony in state court takes about 6-7 months, but it's a good thing. It's a good thing to kind of drag a case out because they want to get the thing resolved. They want to get they meaning the DA, the court, they want to get things resolved. But I never try to rush a case ever.
So what are the main stages in a criminal case that impact how fast or slow it could go?
In a state case, your first date that you're there is an arraignment, and, that's not guilty plea. And then you set it for, and different counties call this next stage different things, but in LA County, we call it a prelim setting date. Some counties call it an early disposition conference, which is kind of funny because I never resolve cases at an early disposition conference. So you stay in, a prelim setting for a while, meaning you keep repeating it until you get all the evidence that you need from the district attorney. And then once you get all the evidence that you think you need, you can try and see if you can resolve your case. And if you can't, then you do a preliminary hearing, which means the prosecution brings in their witnesses and you get to the opportunity to cross-examine them. And so depending on the case, that could be a really key hearing, or because, like, for instance, in LA County, if you have like a child molestation kind of a case, they'll bring in the victim and the alleged victim in the case, and you get to cross-examine that person. Murder cases, it's very important to kind of get your defense out there and see how the witnesses are going to respond to your questions. So prelim settings, you stay in prelim setting mode for, at least 4 months. And maybe you get your prelim done in 6 months. If it's a homicide, you're probably not doing your prelim for a year. Mm-hmm. So after that, then you are transferred usually to a different courtroom where you'll have an arraignment, and then you'll have what's called pretrials. And then after that, you have a trial. So it all depends on where you are and what kind of case it is, how complex it is.
So then with, when you see the difference between a state case and a federal case, does that make the difference as well, like with timing?
Well, federal cases on the whole take longer. They take longer. The evidence is a lot more extensive, although I have one right now that it's not as extensive. I have a federal case right now where I'm going to actually finish it within, I think, 5 months,
Oh,
which I've never done that before. And that's because this person is in custody. They are, and it's because they were in the United States. It's just the sign of the times. They were in the United States illegally, so they were detained because if the judge had granted bail, that person would have been deported. And so that's a way for somebody to get out of being convicted in the United States of, a federal felony and getting potential time is to get bail. Then immigration takes you and sends you back to where you came from. So this person is in custody right now. And so I'm trying to hustle it up because this person wants to go back to their country. So they want to get out of here.
okay.
So as far as a federal case, they take quite some time, and it's not the same. Federal cases are actually done behind the scenes. You don't come to court once a month. Like in state cases, as we talked about, you come to court once a month, once every 6 weeks. But in federal court, you normally don't do that. You have an arraignment, and then you set a trial date, and then the judge sets a pretrial date, maybe 2 weeks before your trial date. So you're working with the U.S. attorney on evidence, on discussing the evidence, on plea agreements,
Mhm.
and then negotiating those plea agreements to the best of your ability. Then there's,
Mm.
if your client does take a plea, then you have a probation report. You're dealing with probation, like that case I was just talking to you about. We're going fast.
Mhm.
This person, I'm assuming, and that's when I'm trying to get this person, is credit for time served. So you've been in for 6 months. That's it. Judge sentences you to 6. You're on your way, and have a good life back in Europe. And now I'm in a big battle with probation because probation piled on this person, piled on these losses, which can't be quantified by them. They can't be supported by the evidence. So we're in a big fight. Me, the U.S. attorney, and probation, because I'm not going to let that happen.
Yeah, yeah, yeah. That's
I don't know
incredible.
if that answered your question.
I think no, yeah, yeah. No, it did. And you gave an experience. I'm like, when you think you're like, I'm in battle with them, I'm like, oh, gonna put up them dukes. Like, I mean, that's
Yeah,
that's
no, it is.
really
I'm pissed off. I get
yeah,
pissed off.
yeah.
I mean,
I get it.
I don't, these people, if especially somebody that I understand that uh, this person, I don't want to say he, she, or they, because, uh, but, you know, if you're in custody and this person particular, I'm sure cannot read English,
Mm,
they're very vulnerable. And
yeah.
and if you think about it, they're relying on me to help them and make this case. And it is because I hear from the family all the time via email, how's it going? What's the update? And, they're very concerned. And so they're very vulnerable. And I just don't like people from U.S. attorney or even U.S. probation. You look for every little nook and cranny to stick it to somebody. Okay. And when we took this plea agreement, um, it wasn't really an issue like that we were thinking would happen. In other words, in federal court, here we go again on a tangent, but in federal court, there's the guidelines, there's guidelines, and that's how a judge kind of starts at the guidelines, and then configure how many months this is worth, this your actions, this is how much this is worth. And then they don't have to follow the guidelines, but it gives them a start. So in this case, we figured the damages are nothing, de minimis. And now probation is coming out with damages from, and where they got the information is the U.S. attorney. They're saying, well, you had all this money that went through your account between 2022 and 2024. So I'm going to use that as the benchmark, which raises your guideline level like 3 times.
Yeah.
And so I've written now the U.S. attorney and said, provide me with the information in writing that probation is relying on to even tell the judge that this person was responsible for those kind of damages. It doesn't exist. In fact, when we're done today, I'm writing probation because I wrote the U.S. attorney yesterday, haven't heard from this person, that U.S. attorney yet. And now I'm writing probation so that I can file a pleading that's objecting to this report. So I hope that, adds some light to something.
Of course. No, I mean, we go off on a little bit of a side quest, but
Yeah,
it shows your passion though, and why you're doing this podcast so people can hear the information. So, it's always good to hear, what you're doing, and it does correlate with what we're talking about today.
good.
Do you see a lot of things like court backlogs, busy calendars and such that make, give delays in court a lot?
It's not really court backlogs. San Bernardino County happens to be one of the busiest places I've seen. But if your client is out of custody, it doesn't matter. It just doesn't matter. There's not really court backlogs. You can use court backlogs to your advantage because when you start getting the pushback from a judge, we need to resolve the case, then the parties, try to get things done, which usually is to your benefit. I can use, the pressure from the judge. Okay, so you want to resolve the case? Okay, fine. We'll take probation. We'll reduce the case reduce the client's felony to a misdemeanor, and we're on our way. So it can be to your advantage when you have that. When somebody is in custody, those backlogs normally doesn't matter. The court is going to, if your client's in custody, the court's going to make sure that whatever day you pick to come back, they'll accommodate you. So backlogs are a good thing for the defense normally.
Then how long does discovery or reviewing evidence usually take, and why is this such a crucial part of the process?
Well, discovery is the bread and butter of your case. I've mentioned in previous episodes, this business of criminal defense work is not about the truth. It's about evidence. And that is the key. And so evidence is what So if you had a jury trial, the prosecution is going to present the evidence that is contained in the discovery. So if a witness goes off sort of script from the evidence that you've had or prior testimony that they've made, then a skilled defense attorney can make them look like a liar because they're changing their testimony. So, discovery is key. You need to get everything. I have a case right now where the prosecution is taking text messages from my client to somebody else, but they're taking text messages which stretch over 2 weeks and then make one long sentence out of it. And making one long sentence out of it takes takes the conversation out of context. And so I'm waiting for them to give me all of the text messages. It's not just the cherry-picked ones that the prosecution is using to create this presumption that my client is saying something that he is not saying. So discovery is key.
Are there pros and cons then between, um, going faster, going slower, like asking for more time? Because I heard, earlier you were saying about, um, sometimes like they want it rushed, so it works in your favor. So you're like, oh, let's just do this, get probation, blah, 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 misdemeanor. Um, is there like a pro or con to ask for more time comparably?
Zero. So last time I was talking about that when a case takes a long time, it's always normally to your benefit, to the defense benefit. It always benefits the defense. Time is really your friend in a criminal case. I mean, one of the reasons is the prosecution's key witness could get hit by a bus. Your prosecution's key witness could forget what they said. So time is always helpful to the defense. It's only when your client is in custody is when, that could be detrimental. They want a result. They want to get out of custody, which of course I wouldn't blame them. But if they're facing a homicide where you're facing life in prison, it's really important to make sure you have everything covered. So to rush things is the only real time that you would want to rush something is when the victim can't be found, the alleged victim can't be found. Then, okay, let's go because I know you don't have what you think you have. That would be about it.
Do you have any like one last important thing to share with the people about, cases dragging on, like if they're frustrated or just the time frames for people so that they know what they're, looking forward to?
I don't think anybody's looking forward to going to court. Okay. I mean, I've had many clients when we finished a case say to me, "Hey, great, you did a great job, but I hope I never need you again." So they're nervous. Most people are very, apprehensive about what's going on in court. And I look at that as part of my job, my service to a client is to make sure I really, really try to make their stress level very low so that I let them know what is going on at all times. Like, for instance, yesterday, we have a case that's been going on for about 6-7 months. And it's only because the DA on the case has not been able to formulate an offer. And it's very important that I get one specific thing out of this case. And she has not like conferenced it with her boss. She can't give me the offer that I want without conferencing it. So the judge had said, okay, no more continuances, like 30 days ago or 6 weeks ago. So we went in yesterday and she says, God, I didn't get an offer yet. Okay, look, my client's out of custody. So I had mentioned to her, I said, well, when we call the case, we'll ask the judge if we could approach the bench that way, because we were watching him chastise the lawyers before us. This case is too long. No, I'm not putting it over anymore.
Wow.
So I said, let's approach the bench and let them know what's going on, because I don't necessarily want to be embarrassed, about this, even though it's not my problem, but let's do that. Let's go talk to the judge privately and tell him what's going on. And we did. The judge could care less. And he just gave us this continuance. The point of the story is after we had left, my client had, emailed me and said, give me a call when you get a chance. So I called him. He just wanted to know. He says, is this a bad thing? And basically I had to let the client know it's not a bad thing. It's not a bad thing. It's not a good thing. She just has not been able to get an offer. The offer that we want to resolve your case needs to be okayed or blessed by somebody higher up in the district attorney's office. So she just hasn't done that yet. So don't worry about it. It's neither good nor bad. It doesn't mean we're not getting, it doesn't mean anything. It's just that she's forgetful is really what I'd say, just so that his mind was at ease. So it worked. His mind is at ease now.
Well, Robert, thank you so much, for showing us your passion and answering our questions today. For those out there, thanks for listening to today's episode of Criminal Law Unfiltered. Criminal cases often take longer than people expect, but the right defense attorney can protect your future. If you or a loved one are facing charges in California, visit robertmhelfand.com to schedule a free consultation with Robert and his team. And don't forget to leave a review, and subscribe so you never miss an episode. Thank you again, Robert, for joining us. We greatly appreciate it.
Thanks a lot for having me.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.